The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated, everyone. It's my understanding that as far as the Appellees, Mr. Graham is going to go first and share time with Mr. Beasley. Is that correct? Correct, Your Honor. Okay. Why don't we start with Mr. Graham, if you would do a quick sound check.
Testing.
Thank you very much, Counsel.
Thank you. And you may be seated. And Mr. Castor, as the appellant, if we'll do a quick sound check, and then you can start.
I'll stand in my normal position, take my mask off. Justice, can you hear me?
Yes. You might want to get a little closer to your microphone.
Try it one more time. Is that better?
It's clear. Thank you.
Thank you.
And Mr. Castor, you can begin.
Thank you, Your Honor. May it please the court, counsel. The appeal presents two issues, the cross appeal one issue. The three issues together are, number one, whether the district court erred in dissolving the LLC based on it being reasonably impracticable when there was no finding of deadlock and the LLC was achieving its purpose. Second issue is whether it was an error to impose remedies other than dissolution when there was no finding of oppression, illegality, or fraud. The third issue raised on the cross appeal is whether there is substantial evidence to support the district court's finding of no oppression. Issue number one, reasonable impracticability. The Iowa General Assembly created limited liability corporations by statute and imbued them with an unlimited duration, as did the certificate of organization for the particular limited liability corporation in question. The statute permits the judicial dissolution of LLCs only under limited circumstances. One of those circumstances is where, and I quote the statute, it is not reasonably practicable to carry on the company's activities in conformity with the certificate of organization and the operating agreement. The other cases for judicial dissolution under the statute require illegal, fraudulent, or oppressive conduct, and those are not relevant to the appeal, although the issue of oppression is relevant to the cross appeal. I want to address three factors that might be considered by this court on the first issue of reasonable impracticability. The factors of purpose, deadlock, and dysfunction.
Well, let me ask a question, Mr. Castor. Assuming this company isn't dissolved and Mr. Barklow is still there, how are you ever going to get any profits out of it, since it requires unanimity to withdraw any profits?
Well, of course, the question presumes that the purpose of the company is to draw profits from the company.
And isn't that the purpose of any company?
The purpose of an LLC can be determined by a contract that's voluntarily agreed upon between the parties. In this case, the purpose of the contract, the LLC, is to hold real estate. And the contract specifically addresses the distribution of profits and provides that profits may be, if there's not unanimous consent, driven back into the company and accrue as capital for the benefit of the owners of the company, the members of the company. And this company was indeed, according to all the testimony of all of the parties, formed for the purpose of holding real estate for the long term. In fact, for generations, because the first amended operating agreement provided that shares, non-voting shares, would be transferred to the children of three of the members. So there's a clear contemplation expressed in writing in the governing documents that the purpose of this company is to hold real estate for the long term. The purpose of this company is not to drive the profits back out to the owners. Now, that doesn't mean that owners of a real estate investment can't use the real estate investment for liquidity when it's necessary for the purposes of borrowing money for some other investments. Those are the sorts of things that business people engage in all the time. But here, the purpose of the company is clear. It's to hold real estate for the long term, not to distribute profits to the individual owners. And the factors that you should consider in determining whether the company is being operated in accordance with that purpose are factors that frankly haven't been adopted by this court to date. But the legislature, by the design of the statute, has at least implicitly, if not expressly, identified one of those factors, which is an analysis of the purpose of the company and a determination of whether or not the company's activities are being conducted in conformity with the certificate of organization and the operating agreement. And here, as I've just said, the purpose of the company has been identified in the certificate of operation, the certificate of organization, and the company has in fact been meeting that purpose. It has been operated for the purpose of obtaining and sitting on real estate, and that real estate has appreciated, and the profits of the company have been driven back into the company.
Mr. Castor, can I divert you real quick from the factors discussion?
Sure.
I want to talk a little bit about the reclassification of the capital as debt. What does the record reflect with respect to the tax consequences, if any, from the district court's order? And maybe it doesn't say anything about that.
You're not to make a pun, taxing my memory. I know that we discussed tax issues in the record. There was an expert who testified, and I think that one of the witnesses testified about potential tax consequences of the reclassification. But frankly, that has not been an issue that has garnered any attention in any of the briefs, and I'm not sure that it's in the appendix for this court's reference.
Back to the factors, is there a risk of a deadlock if we reverse the dissolution? I mean, there's clearly bad blood resulting in all this litigation.
And deadlock, I think, is the single most important factor from the other cases, even though that word isn't used in the statute itself. And the answer is no, there is not a risk of deadlock. In fact, the claims made by Mr. Barklow that led to the lawsuit are that he was being outvoted 3-1 at the corporate meetings. His claim is one of oppression, and he has, and smartly so, cross-appealed the loss of the issue of oppression because it's important for Mr. Barklow to demonstrate not that there was deadlock, but that there was oppression. Because the key votes, the two votes on capital contributions, were votes that were made on a 3-1 basis. In addition to that, even if there were a chance of a 2-2 tie, the operating agreement provides for a method of resolving a 2-2 tie and avoiding deadlock. The method in the operating agreement, which was referred to in the record as a demand vote, is where a member can demand that the votes be equal to the shares that they have in the capital accounts as recorded on the books and records of the company. And those shares have not been equal for many years. So there's not equality among the partners in their capital holdings in the account, and therefore there would not be a deadlock. Even if there were a 2-2 vote, the partners can get around it through a procedure that's stated.
I have a fact question on that. There were payments made in December 15, I think that was for the Schultz contract, and then some other payments made in June and July of 17. The district court recategorized them as loans, is that correct?
Yes?
I'm curious, were any of those actually due or in default? Maybe the Schultz one was due, but were they due or in default? Because it appears there was an amortization schedule or a repayment schedule already in place. And so I'm just wondering if that 2-2 kicks in by capital and all of a sudden people are injecting capital, was it necessary to make those payments at that time?
Yes, and no. Yes, it was necessary. No, the second of those two capital contributions was not for loans that were due or in default. But let me explain why it was still necessary. On the first instance, the first capital contribution, that was a situation where there was a default. I'll bracket that and set it apart. The second capital contribution is to repay what are referred to in the record as the Clark family entity loans. Those loans were not subject to a note in which there was a due date or a repayment schedule. But Mr. Barklow had taken the position that since there was no note, there was no obligation whatsoever to repay those notes. And the payments, the regular payments that had been made prior to a date, I think sometime in 2016, but I may be wrong about the date, the regular payments on the Clark family entity loans were suspended during the time when Mr. Barklow was taking the position that because there had been no paper, there was therefore no obligation to repay those loans. But the entity, acting through the members who voted to repay those loans, took the position that there was a business necessity to repay those loans because you should repay your debts if you're a business. And those debts were debts that were being questioned by one of the partners, so there was a movement to try to get those debts transferred out of the Clark family entities, first into a commercial loan, which was opposed by Mr. Barklow, and so then the only choice left was the capital contribution.
And Counsel, the Clark family loans were to purchase properties for this entity, is that right?
That's correct. The Clark family loans were used to purchase properties minus the cost of the down payment for this entity. That is true.
Counsel, what significance, if any, should the finding that Mr. Barklow engaged or converted money from the entity play with respect to the dissolution analysis?
The dissolution analysis on the prong of reasonable practicability is such that if you follow that prong of the statute, his conduct, his bad conduct is irrelevant. However, he is cross-appealing his loss on the finding of no oppression, which would bring the statute, the other prong of the statute into play, seeking dissolution on the grounds of oppressive behavior. And on those grounds, his conduct is relevant. It's relevant to the exercise of the option to dissolve the company in the first place, as well as whether or not the court's equitable authority ought to be used to do more than dissolution, in this case to recharacterize the capital contributions. The fact that Mr. Barklow not only strangled the funding for the company by opposing the repayment of the Clark family loans and opposing commercial refinancing, but he also engaged in this instance in which he wrote a check to himself, which the court found to be conversion. Those are all instances of his misconduct toward the company. And therefore, he should not be rewarded as the minority member who's attempting to advocate dissolution using essentially a heckler's veto is what I call it. But it's really the language from the Bauer case, which is the law of this court. And in the Bauer case, of course, the court took a look at the Iowa Corporation Statute 490, and the Bauer court said that the court's equitable authority to do something beyond, to fashion equitable remedies, is limited. It's limited by a necessary finding of oppression. And if there's no finding of oppression under 490, the corporation statute, then the court.
I want to follow up on that,
Yeah.
Mr. Castor, on this sort of the question of sort of the legal authority of Judge Miller to do what he did. So, assuming the dissolution was appropriate, and I know you're contesting that, and that's a significant issue on appeal. Assuming that was appropriate, why couldn't he impose additional equitable or take into account other equitable considerations and, in effect, back up the situation? And maybe he backed it up too far. Maybe the appropriate thing is to reclassify the repayments on the family loan, but not the repayments on the outside loan. But why can't he do that?
I think it's a fascinating question, sort of from an academic perspective. The source of the court's equitable authority is really twofold in this case. One is the statute. In this case, it's the LLC statute. And two is the sort of inherent or common law authority or equitable authority of the court in general. And those two things have both been briefed. The equitable authority that emanates from the statute is not available in cases where the dissolution is grounded on reasonable impracticability.
Yeah, see,
Which is,
yeah, and I don't read that way. It says in a proceeding brought under subsection 1, paragraph E, which is the oppression section, the court may order a remedy other than dissolution. I read that as saying, if it's an oppression case, the court can do something different from dissolution. I don't see that as saying in a dissolution case, the court can't do anything more.
well, either way, your reading or my reading of that part 2 of the statute does not create the equitable authority for Judge Miller's ruling. His equitable authority has to come from the common law. It's not coming from that part of the statute which says you can use other remedies. So then you look at the common law cases to determine the limitations on the court's equitable authority. And the limitations on the court's equitable authority are not unlimited and unbridled. And we've seen that in many cases over the years, but in particular and on point in the Bauer case, because the Bauer case at its conclusion is very clear, in which it says that absent a showing of oppression, the court doesn't have any equitable authority. It can't even dissolve the company. And it also says in like the second or third to last sentence that if the court does find oppression, then it can fashion equitable remedies, but we caution courts against fashioning equitable remedies that give the minority member a foothold for oppression against the majority. And that warning in Bauer is exactly what's happened in this case, because as the district court correctly found, it is Mr. Barklow who has engaged in improper conduct. And there's a list of those things in the record.
You may wrap up.
Thank you, Your Honor. That's all I have to say then. Thanks.
Okay, and it looks like Mr. Graham first. And you guys will be responsible for dividing up your time.
Thank you, Your Honor. I'd like to start with a crucial point from the lower court's ruling, in which the court held that that the member's relationship is not repairable, and that certainly the duty of good faith and fair dealing that each must bring to the company will be non-existent in the future. Iowa Code Section 489-409, subsection 4, establishes that in every operating agreement, there's a contractual obligation of good faith and fair dealing between the members. The LLC Code's operating agreement section 489-110 states that an operating agreement may not eliminate the contractual obligation of good faith and fair dealing. So for an LLC to carry on in conformity with the operating agreement, the members must abide by the covenant of good faith and fair dealing, and the court here rightfully held that the good faith and fair dealing has been and will be non-existent between the members. Therefore,
Well, Counsel, if I might, what action by Brian and Jeff did the court find to be not in good faith? As I read that ruling, the capital injections were all found to be proper.
Your Honor, the court certainly held that they were not oppressive. Obviously, I wouldn't be making the cross appeal if he held differently. However, I believe that in that ruling, in those last 2 pages, he alluded to numerous factors that the other parties engaged in, specifically, and I believe Mr. Beasley will touch on, specifically regarding Brian and Jeffrey's conduct as to Joe Clark. And I believe it also left open just the general accusations of impropriety between the two, between Mr. Barklow and the Clarks. And I don't believe he closed the door on the idea that the capital contributions being made over Mr. Barklow's objection is evidence of just a complete lack of good faith and fair dealing between the parties. Otherwise,
Well-
I don't see how the court could have taken those steps to recategorize them as loans.
No, let me ask this good faith and fair dealing, pursue it a little bit. It's kind of an ethereal concept. I mean, and it's often invoked, but oftentimes not described or defined. What specifically will be prevented from happening because of a lack of good faith and fair dealing? How will this directly impact the operation of the LLC?
Thank you, Your Honor. A few examples come to mind. The issues regarding distribution of profits, that requires unanimity.
Sure. But let me stop you. But you don't have to distribute the profits.
No, that's true. Well, then you have the voting. I mean, this operating agreement is light on detail, to say the least. There is no real indication of how these capital accounts should be kept, as you see in most operating agreements. And so there will be arguments down the line as to voting, even if the LLC is allowed to continue, and even if the capital contributions are set as such, there'll be further disputes about that. The court will continue to babysit this LLC, and I believe that's what Judge Miller was getting at when he said that there is just no chance of this company operating at a governance level in the future because the parties just have shown no ability to act with good faith and fair dealing towards each other.
So can I follow up on Justice McDermott's question? Can you identify for me, at least more specifically, the very specific facts that you think show Jeff and Brian acted in bad faith or in an oppressive manner? And then I'll ask the follow-up to it. And I guess my difficulty with your position, at least as I read the record and based on the current findings, is the only finding that anyone acted in bad faith that I see in the record is that Mr. Barklow converted funds from the company. And now the remedy for that is all in his favor, dissolving the company, reclassifying capital contributions as debt. It's very difficult for me to square that in my head. So if you could address both of those things, I'd appreciate it.
Absolutely, Your Honor. Taking them out of order, Mr. Barklow, they achieved a remedy against him, and he owes that money back. Okay, so that money is going back in. He's being held account for that bad action. As to the bad actions of Jeffrey and Brian Clark, again, all the actions they took regarding the 2016 contribution, especially, and as to their brother Joe, which Mr. Beasley will elaborate on, but those were all taken in bad faith. Once they knew that Joe wasn't on board, they said, all right, we're going to dilute you as well. So that's what happened. And it sort of is difficult for me to, our view of the case, obviously, through the cross appeal, is that all these actions taken by Brian and Jeff regarding the 2015 contribution, they wanted to dilute Mr. Barklow going back to 2013. They asked their accountant, how do we adjust Mr. Barklow's interest if we convert these loans to capital? Well, what did the accountant tell them 2 years before they did anything? Well, you can do this, convert the loans to capital. He's down to 1%.
Is that it? I mean, is that your entire theory of bad faith, is the dilution? Are there any other facts that I should be aware of as I'm looking at this case other than capital contributions that you think are important?
I think everything listed in the judge's order, I mean, just the failure to, it's just the relationship is toxic, as the court found. And
So, Counsel,
that's why I'm
let's say that that we're not persuaded by the district court's finding of a violation or a breach of the duty of good faith and fair dealing. We're left with the district court's finding of dysfunction. Is that enough under Chapter 489 to dissolve this company?
Yes, Your Honor, it is. And I would point the court to that South Dakota Kirksey case, excuse me. That court said as long as the company remains control and favorable only to half its members, it cannot be said to be reasonably practicable for it to continue in accord with its operating agreement. And that's what we're going to have here. We're going to have two members.
Can I ask you about Kirksey? Didn't Kirksey also say that the critical fact was it was locked 2-2 and there was no mechanism in the operating agreement for resolving the deadlock, and literally the company could not make a decision, that seems very different than this case.
Respectfully, Your Honor, I disagree. Deadlock was a factor, but they also said that the extenuating factors outside of just the 2-2 vote led to their conclusion that it was just dysfunctional. And the two members, two of the sisters, had, outside of voting, just had complete control of the operation.
Well, counsel, here though, it's at least being presented as almost the way that the entity is operating is such that for its at least daily operations, there really aren't any ongoing disputes, at least at the time that the court entered its order. Is that fair, or have I misunderstood that?
I don't think you misunderstood it. We've skipped over the fact that it's not operating pursuant to an operating agreement. It's operating pursuant to this interim management agreement that the four members entered into to avoid an appointment of the receiver or injunctive relief pending disposition of this lawsuit. It's not, we had to cobble together an agreement that these four could live with in the interim in order to avoid taking the company out of the hands of the four and putting it in the hands of the receiver. So it's operating, but only operating pursuant to this extra contractual agreement, not the operating agreement.
What is the best case that finds or orders judicial dissolution without also finding deadlock?
Complete absence of deadlock. I believe deadlock is a factor in all of them, but the Kirksey case talks about control, not deadlock. The Gagne case talks about dysfunction, and the decisions out of New York and New Jersey cited to in Mr. Katzer's brief also, Mr. Beasley's brief also speak to that.
Wait, I want to clarify. Are you saying there's no case that orders dissolution where there's also not a finding of deadlock? Is that correct?
As I stand here before you today, Your Honor, I cannot think of any. I'm going to turn it over to Mr. Beasley. Thank you, Your Honors.
Thank you.
Good morning. I remove my mask, please. I represent Joseph Clark. He was known throughout the litigation as Joe.
Could you get a little closer to your microphone? There you go. Thank you.
He's known throughout the litigation as Joe, and during the litigation, we were less formal because we were dealing with three brothers, so we referred to him as Joe, Brian, and Jeff. So I apologize for the informality, but I think I'll be consistent with the record. During the litigation, my recollection is that the record referred at times to Joe as the outsider of outside properties. He wasn't as involved as Tracy, Brian, and Jeff at the initial inception of the company. And he didn't become more involved in the company until 2013, when the relationship between his two brothers and Mr. Barklow began to deteriorate. And I think the record is clear that once Joe became more involved in this LLC, he was trying to act as a peacemaker to try to resolve ongoing disputes between his brother and Mr. Barklow. And those efforts failed. That's why we're here today. Joe Clark is positioned on three issues that are presented here this morning. And I have to tell you, when I was trying to figure out what table I should be at this morning, I had to do a little bit of thinking, because there are certain issues that have been raised by Joe's brothers that Joe agrees with, and there's certain issues that were raised by Mr. Barklow that he agrees with. Therefore, with regard to the dissolution, Joe's position is that the district court was correct in dissolving this company under the not reasonably practicable standard. And I think the court's findings, conclusions are instructive on this. And first of all, we're not disputing that the value of the assets have increased. We're not disputing that they're starting to make some money. But with all due respect, 5 of these properties are located literally within a block of Kinnick Stadium and the Children's Hospital. The parties in this litigation are sophisticated real estate people. I'm not, but I might be able to make a go of these properties where they're located. Having said that,
Counsel, over here, sorry. Thanks. One of the allegations is that Joseph's brothers breached a duty of good faith and fair dealing to him by not permitting him to participate in the contribution on the Clark family loans. In other words, that when they paid off those loans, he wasn't invited to do so also, and then that diluted his interest. Do I have that right? Is that accurate?
yes, make sure the record's clear on this. There was a vote, no question, in February of 2016 to contribute money in order to satisfy the Clark family loans. Then what occurred is that there was silence. In fact, during that vote, I think attorneys were present. There was no deadline put on making those capital contributions. Then 4 months went by, and Joe learned, and I think there's emails in the record on this from the accountant saying, okay, how are we going to finance this $950,000 that's going to be put into the company? Joe made it clear at that point he disagreed with the source of those fundings. Then, with no deadline when to put the money in, a check showed up at Joe's doorstep for $316,000. And Joe disagreed with the source of that funding. Subsequently, and it's in the record, and it's in Joe's brief, he reached out with emails over the course of the next several months asking what was the status of this infusion of money. He learned for the first time several months later that his brothers had put in their share, and then 3 days later put in Joe's share, and then several months later claimed he was diluted. With no deadline set in a resolution to infuse that money. So one of the questions that came up in previous questioning here was this idea of bad faith. I don't know that the not reasonably practicable requirement to dissolve requires bad faith. I think certainly dysfunction, if it rises to a certain level, is appropriate to dissolve a limited liability company. And I don't want to understate the level of dysfunction here. These parties can't agree who's going to carry the company checkbook.
Well, there was dysfunction clearly during 2015.
Right.
What is in the record to indicate that there was dysfunction by the time the court issued its ruling?
The fact that a litigation was filed, one party filed for a request for the court to enter a receivership order. One party filed an application for an injunction, and the parties through their attorneys were able to enter into an interim property management agreement. So
You may wrap up.
So do not underestimate the level of dysfunction in this company. But to Justice Manfield's question earlier, if the court determines that dissolution is appropriate, whether the infusion in December of 2015 and June, July of 2016 should be a loan or a capital contribution, I think pursuant to the Iowa Code regarding winding up the affairs, it's irrelevant. The first step is creditors get paid, so those loans get paid back first. Second tier is unreturned capital contributions. So if you treat those infusions as loans, they get paid back first, assuming your winding up includes liquidating these properties. If they're treated as capital contributions, it's unreturned capital, it gets returned then. Then the statute says, and I've read it several times, you divide up any surplus based on, I want to get this right before I sit down because this is important. Equal shares to members. So I would close by saying that Judge Miller, after 3.5 days of testimony and 100 and some exhibits, worked very hard to come up with a ruling that was fair to all the parties. And that's what Joe Clark asked him to do. Try to be fair to everybody here. Thank you.
Thank you. The case of Barklow versus Clark. Oh, excuse me. No, we're not submitted. I had my wingman on both sides letting me know. Sorry about that. Mr. Castor, you get the last word.
Thank you, Your Honor. I'd like to touch on dysfunction and the relationship between Joe and Jeff and Brian on the issue of the second capital contribution and that last point of equal shares, if I can zoom through that quickly enough. With respect to dysfunction, dysfunction alone is not enough to justify the reasonable impracticability standard. Dysfunction is not a legal term of art with respect to corporations, as it's a legal term of art with respect to families. It's used in those kinds of cases, but it has not been recognized as a legal term of art with respect to the dissolution of corporations or the determination of whether they are operating practically or impracticably.
Counsel, on that point, do you draw anything of import in the fact that Chapter 489 and its judicial dissolution provisions doesn't include the same provision regarding deadlock that Chapter 490 does, 490.1430?
I haven't examined the differences that closely, but clearly both chapters allow judicial dissolution, and the Bauer Court says that if that you can have judicial dissolution if you can prove oppression, whereas in 489 you can have judicial dissolution for reasons other than oppression. You can have it for reasonable impracticability. But in that second part, or the last part of 489-701, where it says that Part E, the part that talks about oppression, is the only part where you can use remedies other than dissolution, to me makes those two things be very similar. You need to prove oppression in order to have remedies other than dissolution if it's based on reasonable impracticability. That's my reading of Bauer and the statute taken together. With respect to dysfunction, I would point out to the court that there's no evidence in the record of dysfunction between the three Clark brothers. There's no evidence that there's dysfunction in those relationships or toxicity or animosity. The dysfunction was always between Mr. Barklow and each of the three brothers. Even on the issue of the second capital contribution, where originally Joe Clark voted in favor of the capital contribution and then changed his mind and refused to fund the second capital contribution. The evidence in the record is pretty clear that he voted for it, and the evidence is also clear that the funding was arranged for him. Brian Clark gave him a check that he could deposit to satisfy his capital contribution, but he disagreed about the source of funding and therefore changed his mind. The evidence in the record from Brian's testimony is that he gave Joe Clark until the end of the month to make his share contribution, and that he could have made his share contribution at any time before the end of the year. That's the testimony of Brian Clark, and it's cited in the appendix in volume 4, page 177. But Joe just made a decision not to take part, and he testified about the emails that he sent to Brian discussing his reasons for not putting money in. The fact that he did not participate in the capital contribution is not evidence of dysfunction. It's evidence that he simply disagreed. It has an impact because he at one point agreed to put money in and at another point didn't agree to put money in, so he'll have to live with the consequences of his decision. But it is not a decision that was driven by animosity or acrimony. It wasn't Brian and Jeff trying to prevent Joe from contributing. They tried to arrange the source of funding for him and gave him a check to put in, and he just chose not to do it. And the equal shares argument, very quickly at the end here, that's not before the court today. And I disagree vehemently with Mr. Beasley's reading of the equal shares issue with respect to how ultimately cash will be distributed from the LLC if it is dissolved. But that's not an issue that's before the court today. I'm happy to talk about it in more detail. But equal shares, the shares and the equity interests of the company are determined by the books which were put into record and reflected in the income tax returns at the end of the year, which showed the capital accounts of each person. And their shares are literally the percentage of shares shown on the income tax returns, which they all agreed to up until a certain date. I can't tell whether I'm out or not, but I'm certainly willing to
About 20 seconds.
Well, then I'm just going to wrap it up, Your Honors. Thanks very much for the opportunity to be in front of you today. I appreciate it very much.
Now, officially, the case of Barklow versus Clark et al. Is submitted to the court. And finally, the fourth case from today's morning schedule is State versus Jordan, and it is hereby submitted without oral argument. Court is adjourned.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.